A single executive order is challenging a right that has been guaranteed since 1868. The Supreme Court is now deciding whether the president has the power to redefine who is actually born American. 150 years of constitutional understanding hangs in the balance, and the answer could change everything about what it means to be a citizen of the United States. Welcome to Court Decoded. Today we cover the historic Supreme Court showdown over birthright citizenship, examining whether executive power can override the Constitution itself. In early 2025, President Donald Trump signed an executive order that sent shockwaves through the legal community. The order sought to redefine birthright citizenship, attempting to exclude children born on American soil to parents who are undocumented immigrants or on temporary visas. Within hours, legal challenges erupted across the country. Federal judges in multiple states issued injunctions blocking the order. The cases moved rapidly through the courts, and now the Supreme Court faces one of the most consequential constitutional questions in decades. At its core, this battle asks a fundamental question. Can any president, through executive action alone, override a right explicitly written into the Constitution? The stakes extend far beyond legal theory. Millions of American citizens could see their status questioned. The very definition of American identity hangs on how 9 justices interpret 14 words written over 150 years ago. To understand this case, one must travel back to 1868, just 3 years after the Civil War ended. The nation was grappling with a horrific Supreme Court decision from 1857, Dred Scott versus Sanford, which declared that Black Americans could never be citizens, regardless of whether they were free or enslaved. The 14th Amendment was ratified specifically to destroy that ruling forever. Its opening words are unambiguous. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. These 14 words established birthright citizenship as constitutional bedrock. The framers of this amendment deliberately chose broad, inclusive language. They wanted no future government, no legislature, no president, no court, to have the power to strip citizenship from those born on American soil. For over 150 years, this principle has remained virtually unchallenged, until now. The Supreme Court has already ruled on birthright citizenship, and the decision could not be clearer. In 1898, the justices decided United States versus Wong Kim Ark. Wong Kim Ark was born in San Francisco to Chinese immigrant parents who were legally prohibited from ever becoming citizens themselves under the racist Chinese Exclusion Act. When Wong returned from a trip to China, the government denied him re-entry, claiming he was not a citizen. The Supreme Court ruled decisively in his favor. The court held that the 14th Amendment means exactly what it says. A child born within the United States, regardless of the parent's citizenship status, is an American citizen by birth. The decision was 6-2. Justice Horace Gray wrote that citizenship by birth is established by the mere fact of birth under the circumstances defined by the Constitution. This precedent has stood for over 125 years. No subsequent court has overturned it. The administration's legal argument hinges on 5 crucial words: subject to the jurisdiction thereof. Attorneys defending the executive order argue these words create an exception. Their interpretation suggests that children of undocumented immigrants are not truly subject to American jurisdiction because their parents owe allegiance to foreign nations. They point to the original debates surrounding the 14th Amendment, where senators discussed excluding children of foreign diplomats and members of occupying armies. However, constitutional scholars overwhelmingly reject this interpretation. When the amendment was drafted, the phrase subject to the jurisdiction was understood to mean subject to American law. If someone commits a crime on American soil, they face American courts, that is, jurisdiction. The only recognized exceptions are children of foreign diplomats with immunity and children of enemy soldiers during an active invasion. Undocumented immigrants are absolutely subject to American jurisdiction. They can be arrested, prosecuted, and deported under American law. The very existence of immigration enforcement proves they fall under American jurisdiction. Beyond the citizenship question lies an equally profound constitutional issue. The limits of executive power. The Constitution establishes a clear hierarchy. Constitutional amendments sit at the apex of American law. They cannot be overridden by statute, and they certainly cannot be nullified by executive order. An executive order is simply a directive from the President to federal agencies about how to implement existing law. It cannot create new law, and it absolutely cannot contradict the Constitution itself. If a president could override constitutional amendments through executive action, the entire framework of American government would collapse. The First Amendment's free speech protections could be suspended. The Fourth Amendment's prohibition on unreasonable searches could be eliminated. The separation of powers, the foundation of the Republic, would become meaningless. Lower courts have unanimously recognized this principle in blocking the executive order. Multiple federal judges, appointed by presidents of both parties, have ruled that the order exceeds presidential authority. The oral arguments before the Supreme Court revealed the justices grappling with unprecedented questions. Attorneys for the administration argued that the executive branch has broad authority over immigration matters and that defining citizenship falls within that power. They urged the court to revisit Wong Kim Ark, suggesting the 19th century decision did not contemplate modern immigration realities. Attorneys challenging the order presented a straightforward constitutional argument. The 14th Amendment's text is clear. The Supreme Court precedent is clear. 150 years of consistent application are clear. No executive action can override any of these. Several justices posed pointed questions to both sides. Questions arose about what limiting principle would exist if executive orders could narrow constitutional rights. Other questions probed whether the administration was asking the court to effectively amend the Constitution from the bench. The justices appeared deeply aware that their decision would echo through American history. History offers sobering lessons about citizenship rights and government overreach. During World War II, the government stripped Japanese Americans of their liberty through executive action, forcing over 120,000 people into internment camps. Decades later, the nation formally apologized and paid reparations, acknowledging the constitutional violation. The consequences of this current case extend far beyond legal theory. If the executive order were upheld, it could affect an estimated 4.4 million children born to undocumented parents since 2009 alone. These are Americans who have never known another country. They have attended American schools, pledged allegiance to the American flag, and built their entire lives as citizens. Creating a new category of American-born non-citizens would generate unprecedented legal chaos. Questions of inheritance, property rights, employment eligibility, and civic participation would multiply exponentially. The social fabric of countless communities would be torn apart. Legal experts across the political spectrum have expressed alarm about the broader implications of this case. Conservative and liberal constitutional scholars have found rare common ground in opposing the executive order, not because of immigration policy preferences, but because of fundamental concerns about constitutional structure. If the Supreme Court were to uphold executive authority to narrow constitutional rights, it would establish a dangerous precedent. Future presidents of any party could claim similar power to restrict other amendments. The Bill of Rights would become subject to executive whim rather than constitutional amendment. The framers of the Constitution created an intentionally difficult process for amending the document. It requires 2/3 of both houses of Congress and ratification by 3/4 of state legislatures. This demanding threshold exists precisely because constitutional rights should not change based on political winds. They should only change through deliberate, broad-based consensus of the American people. The Supreme Court's decision in this case will define the boundaries of executive power for generations. Lower courts have unanimously ruled against the executive order, finding it unconstitutional on multiple grounds. The 14th Amendment's plain text, the Wong Kim Ark precedent, and fundamental principles of constitutional supremacy all point toward the same conclusion. A president cannot override the Constitution through executive action. Whatever the final ruling, the legal lesson is clear. Constitutional rights exist precisely to limit government power. They cannot be wished away by any branch of government, no matter how politically convenient. The Constitution belongs to the people, and only the people, through the amendment process, can change it. The framers of the 14th Amendment wrote its citizenship clause in clear, simple language for a reason. They wanted no future generation to question its meaning. If this constitutional showdown fascinated you, subscribe to Court Decoded and hit the notification bell. Every week, we break down the legal battles shaping American rights. Share this with someone who needs to understand what is at stake.